In terms of government agencies, one of the things that sets prosecutor offices apart is that we are agencies of attorneys. And there are certain laws and certain ethical duties as attorneys that require us to have levels of cybersecurity that will protect important confidential data. So that's what I'm going to talk for a few minutes about. So let's first talk about statutes, about legal obligations to maintain cybersecurity. And one thing that PC has been doing over the last few months is surveying the laws and the ethical duties across all 50 states in the country. And to break it down very simply for our purposes today, there are two general type of statutes that might end up requiring a prosecutor's office to implement reasonable security standards. One set of statutes kind of directly say that, and they're usually built around the retention of personal identifiers. So in other words, if a government agency holds personal identifiers in their data in some way, shape, or form, these agencies have a legal responsibility in approximately 20 states to maintain and implement what's usually described as reasonable cybersecurity procedures. And as lawyers, we all know what words like reasonable mean. It means there's some openness to interpretation, and legal decisions will define them for us as the years go on. But it's basically a heads up that if you have personal identifiers in your data, you must have cybersecurity that reasonably protects them. And the sensitivity of the information impacts what that definition of reasonable will be. Now, of course, DA's offices, prosecutor offices have personal identifiers, not only those of their staff, for HR purposes, et cetera, but also those of witnesses and victims. Also those contained in things like medical records, financial account records, communication account records that we're obtaining as evidence in cases. In some places, there may be even identifiers connected to police officers and law enforcement agents. So there's no doubt that our offices are holding these identifiers, and these laws tell us that since we have them, we better have reasonable security protection for them. Then there's another set of laws that have to do with obligations in the aftermath of a data breach that exposes personal identifiers. In over 35 states, government agencies have an obligation to disclose such a security breach and to notify affected parties. And there's all kinds of details about how those disclosures and notifications have to be performed depending on the state law. But in making this legal obligation, what these laws are basically saying is that offices need to be monitoring for the possibility of a data breach and then disclosing and notifying in the event they've discovered one. And that sort of implicit monitoring aspect, because how do you know you have a data breach unless you find out, like Jed Painter said, on the day you have to unplug the computers. I mean, hopefully you're identifying these things beforehand, which implies a level of cybersecurity and protection that's being employed as well. So if you are, sitting in your office thinking, what does that mean for my particular state, my particular office? Those are good questions. And, I'll be talking a little bit about a resource, just knowing what your state's laws are. But assuming your state that has one of these laws, the first question is, does it cover district attorney's office? What government entities are being referred to? And that varies a little bit state by state. Some clearly encompass every type of government agency, including a prosecutor office. Some limit it to state agencies, but then you have to ask the question, is the DA's office a state agency in your state, or is it a local agency, which can vary a little bit? But those are points you have to consider. And then, of course, just what is required for compliance with these laws. So that's sort of the general legal landscape when it comes to cybersecurity duties. But then as lawyers, of course, we have professional duties in a variety of areas. And in the US, those rules of professional conduct are sort of generally laid out by the American Bar Association, which makes model rules, which have been adopted either verbatim or, in vast majority followed by every single state. So even in the states, in other words, that haven't just adopted these ABA rules verbatim, they have been incorporated and subsumed in those other state laws too, state rules too. And there are many, many rules in the model rules, but the ones that intersect with the issue of cybersecurity are the ones that are laid out in this slide: competence, communication, information confidentiality, duties to former clients, property safekeeping, and then the responsibilities of supervising other lawyers and non-lawyer staff. And I feel like when you read this list, you can sort of immediately see how there's an intersection with data and with security. All communication, all information, for the most part nowadays that we're dealing with is digital. And our clients as prosecutors may not be the private clients of a law firm or a solo practitioner, but they are our communities, they are our jurisdictions, they are our victims and witnesses, and that's whose digital information that we are required to safeguard in various ways because of these rules. And also to make sure that if we're supervisors, that the lawyers and non-staff in our offices are handling responsibly. So, for example, these rules have, were written and updated over the years, but through comments and opinions that the ABA produces, there have been specific references to the need for security in a technological way. For example, the rule of competence, which in a nutshell says lawyers have to competently, skillfully, knowledgeably represent their clients. There was a comment added, comment 8, which says that means keeping abreast of changes in technology. You cannot be a lawyer today and not be abreast of technological changes and innovations. When it comes to confidentiality or communicating properly, you have to be doing so digitally, and that means you have to be taking technological steps to fulfill these ethical obligations. Now, the ABA also issues formal opinions on specific issues that come up under these rules, and these formal opinions also are often adopted verbatim by states, and if not verbatim, incorporated in those states' own formal opinion systems. And there are many of them that touch on cybersecurity and data security, but the two I would highlight today are the ones listed here, number 477R and number 483. And the first one has to do specifically with what does it mean in a technical environment to be securing confidential communications and confidential client information. And it's an opinion of several pages, but some of the nuggets of importance for us is that it means lawyers have to have training in technology and the use of technology, and have to have training in information security, and that has to be ongoing training in an updated fashion. And in fact, partly in response to these opinions, several states, including New York, have CLE requirements in these very areas outlined in this opinion. Lawyers need to understand and use reasonable security measures when they're communicating client information or with clients, and in safeguarding their data. And importantly, too, there's sort of a due diligence requirement in terms of the security of the vendors or third parties you're dealing with. Is their security up to snuff so that it's not going to impact your representation of your clients and your work? And then 483, which is focused on what a lawyer is supposed to do if they have been the victim of a data breach or a cyber attack. In discussing that scenario, goes to some lengths to talk about what a lawyer's cybersecurity obligations are, generally speaking, to avoid the attack in the first place. And lawyers are supposed to monitor for, investigate, and stop data breaches. That is a duty of cybersecurity that is outlined in that opinion. And then, of course, if the worst happens, to make notifications as laws require to affected parties. The opinion also describes a lawyer's need for a cyber incident response plan. So that means that lawyers in a DA's office or any office should be developing a response scenario ahead of time, as they would, as people have already discussed, with an active shooter or a fire or a hurricane or what have you. There should be a plan in place about what to do, who's going to do it, who to reach out to for assistance, all of those things ahead of time, because that is going to help mitigate the repercussions on your work, on your client's representation, should an attack occur. So what we've been doing at PC this summer is putting together a hopefully very useful chart that outlines the rules of professional conduct, the ethics opinions, and the statutes that affect lawyers' obligations, that outline lawyers' obligations in this area, but particularly prosecutors. So this is just a little screenshot of one state. Some states have many ethics opinions in this area, or multiple statutes that might apply. In Alabama, it's a little more streamlined, but as you can see, they issued an opinion about cloud computing 10 years ago or so. Things like that are useful to know. And if you're curious, or not just curious, but want to be aware of what the laws and rules are in your state, hopefully this will be a resource. We're finalizing the chart now, and once it is available on our website, we will inform you so that you can use it as a resource whenever you like. One other area about data security that's specific to prosecutors that I think it's useful to be, at the end of this lecture, having a conversation with your IT department about, in terms of how this is going in your office. And that has to do with grand jury secrecy. And I know some states don't use the grand jury very much, or use it only once in a while. Other states like New York use it all the time. But as everyone knows, grand jury proceedings are secret, and that laws usually encompass somewhere in the criminal procedure rules of your state, as it is in Colorado, where I am. Grand juries are investigative bodies. Typically within the procedural rules, they are overseen by a court. They are administered by prosecutors who are appearing before the grand jury, obtaining subpoenas, presenting evidence, presenting testimony, etc. But whatever is happening there by law is meant to be kept secret. So what does that mean? And this is the question to ask about the digital data connected to the grand jury, the evidence, the minutes, the transcripts, who's keeping that and who has access to it? Now, typically prosecutors are furnished with access and in fact tasked with maintaining that evidence and those transcripts by the court overseeing the grand jury, by some type of court order. And that court order typically specifies who is to be furnished with the access and who is to maintain that information. And in some places, that order might say something like the DA's office, without being more specific. Or in some places, it might say these specific prosecutors or investigators or things like that. But whoever's been granted access is really the only people who should have any access to that data. And if that doesn't include your IT staff, your county or private IT assistants, or any other people in your office or out of the office, then there should be certain data protections put into place to make sure that's the case. And that might be additional layers of passwords and authentication. That might be storing the data outside of your case management system or something like that. But this is just a question to be considering in terms of complying with the grand jury secrecy laws in your particular jurisdiction.